Be ready? Start. Relying on the case, it was contended by the learned counsel for the appellant that there is a presumption that parents will be able to exercise good care in the welfare of their children. Stop. It was argued by the learned counsel on behalf of respondents that the impugned order warrants no interference. Stop. Before passing the impugned order, the learned judge had spent over 1 hour with the children to ascertain their preferences. Stop. The children have been living with the respondents since their mother's death in June 2006, as the High Court had stayed the order of the family court vacating the injunction order. Stop. While the respondents had been complying with the visitation rights granted to the appellant, the children were not happy with the treatment meted out to them during the time they spent with their father and stepmother. Stop. In contrast, respondent number 3, contrary to the apprehensions expressed by the appellant, has stated on record that she had no intention to marry and would devote her life towards the welfare of the children. Stop. Respondent further asserted that the cited cases are not applicable to the facts of this case. Stop. Stanza. We have heard the learned counsel for both the parties and examined the impugned order of the High Court and also the orders passed by the family court. Stop. After considering the materials on record and the impugned order, we are of the view that at this stage the respondents should be given interim custody of the minor children till the disposal of the proceedings filed under Section 7, 9 and 17 of the Act. Stop. Section 12 of the Act empowers courts to make such order for the temporary custody and protection of the person and property of the minor as it thinks proper. Stop. In matters of custody as well settled by judicial precedents, welfare of the children is the sole and single yardstick by which the court shall assess the comparative merit of the parties contesting for custody. Stop. This court had observed in this decision that custody orders by their nature can never be final. However, before a change is made, it must be proved to be in the interim custody of the father as against the maternal grandparents. This court held that the division bench appears to have lost sight of the factual position. Stop. Stanza. At the time of death of their mother, the children left in custody of their paternal grandparents with whom their father is staying, and the attempt of the respondent number 1 was to alter that position before the application filed by them is considered by the family court. Stop. For his purpose, it was very relevant to consider whether leaving the minor children in custody of their father till the family court decided the matter would be so detrimental to the interest of the minor that their custody should be changed forthwith. Stop. The observations that the father is facing a criminal case, that he mostly resides in USA, and that it is alleged that he is having an affair with another lady are, in our view, not sufficient to come to the conclusion that custody of the minors should be changed immediately. Stop. What is important for us to note from these observations is that the court shall determine whether in proceedings relating to interim custody there are sufficient and compelling reasons to persuade the court to change the custody of the minor children with immediate effect. Stop. Stability and consistency in the affairs and routines of children is also an important consideration, as was held by this court in another decision cited by the learned counsel for the appellant. Stop. Stanza. We are convicted that the dislocation of Satpal at this stage from Allahabad, where he has grown up in sufficiently good surroundings, would not only impede his schooling, it may also cause emotional strain and depression on him stop. After taking note of the marked reluctance on part of the boy to live with his mother, the court further observed, under these circumstances and bearing in mind the paramount consideration of the welfare of the child, we are convicted that child's interest will be best served if he continues to be in the custody of the father. Stop. In our opinion, for the present, it is not desirable to disturb the custody of Master Satpal, and therefore the order of the High Court giving his exclusive custody to the father with visitation right to the visitation to the mother deserves to be maintained. Stop. The children have been in the lawful custody of the respondents from October 2007. Stop. In the case of custody of the Rajpal Singh Sumesh Nagal, it was argued before this court by the counsel that welfare of the child should be seen. Stop. Stanza. The learned counsel for the appellant has placed reliance on the case of Mohsin Reshma. Stop. In this case, the High Court had set aside the order of the civil judge granting the custody of the child to her mother's paternal aunt while the father was not proven to be unfit. Stop. However, the High Court of Rajasthan held that in the light of Section 19, which bears the court from appointing a guardian when the father of the minor alive and not unfit, the court could not appoint any maternal relative as a guardian, even though the personal law of the minor might give preferential custody in her favor. Stop. As is evident, the aforementioned decision concerned appointment of a guardian. Stop. No doubt, unless the father is proven to be unfit, the application for guardianship filed by another person cannot be entertained. Stop. However, we have already seen that the question of custody was distinct from that of a guardianship. Stop. Senja. As far as matters of custody is concerned, the court is not bound by the bar envisaged under Section 19 of the Act. Stop. In our opinion, as far as the question of custody is concerned, in the light of the aforementioned decisions, the personal law governing the minor girl dictates her maternal relatives, especially her maternal aunt, shall be given preference. Stop. To the extent that we are override his rule of Mohammedan law, and hence a prima facie case is found in favor of the respondents. Stop. Stanza. Further, the balance of convenience lies in favor of granting custody of the maternal grandfather, aunt and uncle. Stop. A plethora of decisions of this court endorse the proposition that in matters of custody of children, their welfare shall be the focal point. Stop. Once we shift the focus from the rights of the contesting relatives to the welfare of the minor children, the considerations in determining the question of balance of convenience also differ. Stop. We take note of the fact that respondent number 3 on record has had resigned from her job as a technical writer to take care of the children remains uncontroverted. Stop. We are hence convinced that the respondents will provide sufficient love and care for the children till the final disposal of the guardianship application. Stop. There are sufficient and compelling reasons to persuade the court to change the custody of the minor children with immediate effect. Stop. Stability and consistency in the affairs and routines of children is also an important consideration, as was held by this court in another decision cited by the learned counsel. Stop. Over.